for being here. We're going to start with the agenda, that being, and let me make sure I address this. As this is a subcommittee meeting, I've been advised that a quorum is present with the three members that are here now. So, having said that, and I'm out of breath because I just ran up the stairs, we're going to start with Senate Bill number 2253. Senator Simmons, this is your bill. Would you like to present this?
Thank you. Thank you so much, Mr. Chairman. Senators, we've actually passed this bill a few times on the Senate side. And basically, what it does, it establishes a first offense non-adjudication for DUI for drivers who may have a CDL, but at the time of the actual stop, they were driving their personal vehicle. Right now, under current law, a person who receives a DUI as a first offense, the law allows them to get a non-adjudication as a first offender. For those individuals or drivers in the state of Mississippi who may have been driving their personal car at the time of the stop and got received a DUI, they don't have the same benefit. We are not changing the law if the person is driving the commercial vehicle at the time they receive a DUI. We are not changing that part of the law. The only part of the law, Mr. Chairman and members of the committee, that we are doing is trying to give a CDL driver the same benefit another driver in Mississippi receives when he or she is driving their personal vehicle. That's an explanation of the bill, and the language is on lines 49 through 51. And I'll yield to any questions, Mr. Chairman.
Any questions? Any questions? Seeing none, there a motion?
Title sufficient do pass, Mr. Chairman.
All in favor say aye. Any opposed, like sign. That bill will be referred out. Next up is Senate Bill number 2260, right to counsel, authorize a state defender to provide where there is a constitutional right. Find that in your paperwork. It looks like we have with us today head of the State Public Defenders Program, Jud A. This bill comes at the request of the chairman, Senator Wiggins. Mr. Degree would, I think after speaking with Chairman Wiggins, he said this was at your request. And if it is, would you like to advise the committee of this bill?
The bill, it does two things. The standard setting, which is subject to Supreme Court approval, is the first recommendation from the Public Defender Task Force, that just so that both consumers of indigent defense service as well as judges and funders and the lawyers know what is expected of you as a public defender. I think we've got some folks, the entire committee has done this, where you have people asking, they want you to do conditions, complaints, and other things, and you got to tell your client, this is all I do. I'm just limited to representing you in this matter. And then, you know, when the county is funding this, they need to know what to expect from their public defenders. So this came out of the Sixth Amendment Center study, and then the task force adopted it as the #1 recommendation. It has the support of the Mississippi Bar. They've reviewed this. They think this having uniform standards, and that's all it does, is give the standards. In most other states, there's a commission that oversees the public defender, and that commission be the one that actually promulgates the standards or approves the standards. Because we don't have that here, that's the reason why it goes to the Supreme Court. And you know, I think it's probably more proper at the Supreme Court anyway, because all lawyers are governed by the Supreme Court. The other provision that allows us to assist beyond right now, we're allowed to assist at the trial level with just death penalty cases. That this would, we're actually doing more than that. We're working in Hinds County, both through an ARPA-funded project and funding specifically to the county where they're just doing general indigent defense work. And so we're doing that based on a specific authority in the appropriation bill, and this would allow us to put it into general law.
Before I open it up to questions, I do have a question, Mr. Degree, and that is, do you have your bill? Okay. On line 29, and I think we can all appreciate that everyone playing on, by the same rules is fair for everyone, and consistency and transparency are the best policy. I do have a question, though, with regard to if you guys are promulgating, implementing, how would you be enforcing the standards?
Well, I don't think we would have any way to enforce the standards. That language came from the Sixth Amendment Center report. I don't think, other than, I guess, making as all lawyers, if it was a ethical violation of rules of professional responsibility, we're already obligated to refer that to the bar.
Yes, sir.
Standards violation, other than just notifying the county, whoever's funding them, that you have a problem, or we could reference the Supreme Court as the Supreme Court justice who testified in October said, they don't have real authority to enforce their rules, so
Right.
enforce mine. So I'd just be honest, I don't know that there's no enforcement mechanism.
I understand. But before I ask, are there any amendments? Would there be any other questions from committee member or anyone other in this room? All right, with no further questions, we have an amendment.
Thank you, Mr. Chairman. I'd just like to, just delete, where it says and enforce and place the and in front of implement. So on line 29, it will read, the state defender shall promulgate and implement standards.
Yeah, and we'll have I guess there's a motion been made to amend that to exclude the word enforce and effectively read, the state defender shall promulgate and implement standards that would define how effective indigent defensive service. Is that correct?
Correct, Mr. Chair. That's correct, Mr. Chairman.
All right, so there's been a motion to amend. All in favor of that motion? Any opposed to that motion? All right, so the amendment will carry. With that being said, is there a motion?
Title sufficient do pass as amended. Committee sub, title sufficient do pass committee sub.
All in favor? Any opposed, like sign? That will be brought out as amended with the committee sub. Next on the agenda, and again, I know it's 4:10 at this point, so I'm trying to get through this as swiftly and as efficiently as possible. Senate Bill 2821. Thank you, Senator Sparks, for being here. If you will you please give a brief explanation of this bill?
Thank you, Mr. Chairman. It will be very brief. We're bringing forward the code sections addressing intervention courts. I do notice there are a couple of situations where they have replaced the ST after 31, 31st. There's technically not supposed to be anything except the code sections brought forward. The only thing that I see is that that's been taken out. The purpose of that is to address, we've got several different tracks going on in our intervention courts, drug, veterans, mental health, and that it is a good time for us to look at how we can help maximize that. I met with two of our drug court judges this past week to get input from them, as well as the advisory committee. But at this point, we have brought those code sections forward for further amendment. I'll yield any questions.
Thank you for the explanation, Senator Sparks. Are there any questions? With there being no questions, is there a motion? All in favor say aye. Any opposed, like sign? Yes, sir. Yes, sir. Thank you for coming. That will be brought out of committee. Next up, we are brought to Senate Bill number 2529. This is a bill, I believe, if I can get to that, that is proposed by Senator Fillingame. Yes, thank you. So 2529 is a bill that is proposed by Senator Fillingame. The purpose of requesting this bill is when a district attorney's office has to travel outside of district to, for conflict counsel. Hypothetically, let's just say the district attorney in Lincoln County had to travel to an Adams County district to prosecute a case as conflict counsel. It is my understanding, as the law is currently framed, they have to pay for that themselves. And what this does is it changes that. Does anyone have any questions about this bill? Is there a motion? All in favor say aye. Any opposed to it? That will be brought forward. Senate Bill number 2386, inasmuch as this is used, the funding or the payment of appointed counsel outside of outside of public defender's office, at least in my district, those numbers have been capped at a very minimal threshold. As you can see in lines 11 and lines 15, you'll go to page 2, lines 20, line 23. This is amending that cap, that statutory cap for compensation of appointed counsel upwards. And I think this is, quite frankly, a step forward. If you've ever had a case, be it murder or anything else, you may think that $5,000 is not enough as it is, but I think this is a step forward. So providing that brief explanation on Senator Wiggins' bill, is there a motion?
Just one question. For contract or salary, not salary, but public defenders in counties that are getting paid, this wouldn't change the authority that senior circuit court judges have in appointing those private attorneys to cases, and in the event that those attorneys submit bills to those senior circuit court judges, that wouldn't change that function as it currently stands, would it?
That is not the intention of this bill. However, if you would like to make a motion to table this or insert a reverse repealer, but as you can see in line, and thank you to Ethan, as you can see on line 28 through 31, the fees and expenses as allowed by the appropriate judge shall be paid by the county treasurer out of the general fund of the county in which the prosecution was commenced. I think the answer to that is no. You're still going to be paid based upon what the judge orders, but I think this provides a rubric or a better framework for appropriate compensation. This is state dollars, I think is what council was saying, as opposed to the county treasurer.
Very well.
Is there a motion?
I just vision do pass, Mr. Chairman.
All in favor? Any opposed? That will be brought forward. Finally, we have with us Senator Jeff Tate here to explain Senate Bill number 2518, the prohibition of political candidates from addressing the public during court terms. Senator Tate.
Chairman, this is a simple, printed front and back, only one page, as all bills should be. It simply does is it will not allow for a judge to give time for candidates to be able to politic a jury. We all know most people, when they get a jury summons, they try to get out of it. They don't want to be there. The last thing that we need whenever they're making a difficult decision is to have people come in there in grandstand to try to sway to get their vote. And so that's an explanation of the bill. I'll be happy to take any questions.
Senator Tate, I do have a question. Is your concern brought upon by circuit clerks or is there someone in particular? Have you been a member of a jury in which this stopped the trial? I'm just curious.
No, I have not, but yes, this does come from the circuit clerks, but also I think more judges don't want to come out and say this, but they feel compelled that they have to give time to candidates. And so I would say that it's a bill not directly from them also, but I've reached out to several counties. This has bipartisan support. A majority of the counties represented here today, their circuit clerks are in agreement. I know that the last time that we had an election dealing with one of these that are mentioned, we had to have court stopped for that. I understand that Madison County has had this problem here very recently, and I'd be happy to give a list of all the counties that we've reached out to just in the past couple hours, since I knew that this bill was actually going to be sent to this subcommittee to let you know just exactly how much support there is and how little there is of people being against it.
Sure. And as you know, as we spoke in full candor, I have a bill proposed that does the exact opposite, that says, if in fact you're going to let people speak to a circuit court jury, you should allow political candidates to speak to a county court jury. Either way, I think the purpose would be to make it fair either way. Having said that, are there any other questions? Senator Simmons.
Thank you, Mr. Chairman. To Senator Tate, what happened with this bill when we had it last year?
We passed it in the Senate and it died in the House.
Okay. And I think I was one of the ones that I opposed it, and I opposed it because, and I still have that position, and I just want to be honest with you about, are we getting into the province of trying to tell judges how to run their courtrooms? I think what we want to do is just make sure they are fair and treat everyone equally, but do we want, as the legislative branch, to get into the province of telling, because the bill reads, no judge of any circuit court may provide an opportunity for a candidate for justice of the Supreme Court, judge of the Court of Appeals, circuit judge, or chancellor to address the public. So we basically telling our circuit court judges what they should not do. And I respect you saying you talked to the circuit clerks, but when it came up last year, I mean, my senior circuit court judge, Ashley Hines, for the Fourth Circuit, he took a position that, if I got a trial going on and I don't want anybody to speak because it's gonna be a long trial, I'm not gonna let anybody speak. But if it's a trial that's gonna last 1 or 2 days, I may decide they can speak after the jury goes back. I mean, I'm just saying, this is a conversation I had with my judge, and I talked to more than one judge, and they just seems to feel like we are getting into the business of trying to tell them how to run the courtroom.
I would say that bill was 2 sessions ago, and that bill was actually a double layered bill. It had this in it, but also what caused all the angst is that the bill was going to allow for judges to not necessarily affiliate with a political party or run as a political party, but to be able to say that, I am Republican, I vote Democrat. Right now, they can't say that. So that bill that you were in opposition of 2 sessions ago, because we didn't have this bill last session, 2 sessions ago, we voted on it. It was double layered. So I think that's where all the angst came from 2 sessions ago.
But I guess lines 13 through 18 it does what?
It's going to do what you just said. In other words, it wouldn't allow the circuit judge to, just like how they can't do in county court, they can't do in justice court. So make it where circuit court, it's just like the rest. Chancery court, where you have a jury, I guess you don't have a jury in justice court, but it would just make it where, as far as going to the court, you can't. It's a place to leave politics out.
I have a motion at the appropriate time, Mr. Chairman.
Are there any other questions? Motion, Senator Simmons.
Mr. Chairman, I'd like to amend it to add a reverse repealer.
There's a motion to insert a reverse repealer. Any questions about that motion? All right, all in favor of that motion, vote aye. Aye. Any opposed? Motion carries. There will be a reverse repeat.
I have another motion, Mr. Chairman.
All right. What is that motion?
Mr. Chairman, I'd like the latest bill on the table, subject to call of the chair.
All right. Any, as to the vote of that, all in favor of laying it on the table? All opposed? Aye. All right, so that will be referred out with a reverse repealer in it. Oh, I'm sorry. Thank you, Senator Barr, Senator Tate. All right, as to the vote on the amended bill with the reverse repealer in it, or committee sub, all in favor of that, say aye. All opposed, like sign.
No.
All right, the bill will be referred out. And is there any other motion?
Rise report, Mr. Chairman.
All in favor?
Aye.
Any opposed? All right, we are adjourned.